Not everyone is legally entitled to have reasonable adjustments made for them. In law, the duty to make reasonable adjustments for somebody only applies to those who are disabled. Disabled has a specific definition under the Equality Act 2010, which is the key piece of anti-discrimination law in the UK. And to be classed as disabled, and therefore to benefit from certain specific rights under the Equality Act, such as the duty to have reasonable adjustments made for you, you have to meet this definition. The definition may be wider than what most people commonly think of as a disability, and is broken down into 4 essential questions, all of which must be answered to complete the definition. So firstly, does the person have a physical or mental impairment? There's no definition of this phrase. The guidance just says that it's the effect of the disability and not the cause, which is the key. So a physical impairment would be something that restricts you physically, and a mental impairment could cover a wide range of impairments relating to mental functioning. Secondly, does this impairment have an adverse effect on your ability to carry out normal day-to-day activities? So day-to-day activities are things that people do on a regular or daily basis, such as shopping, reading, writing, using the telephone, getting dressed, performing household tasks, using transport, and that sort of thing. These do not include specialized work activities, but they can include general or more typical work activities, such as typing or being able to use the phone. So, does your impairment have an adverse effect on your ability to do those things? Thirdly, is that effect substantial, which means more than minor or trivial? Finally, the 4th question is whether the effect is long-term, meaning it has to have lasted for at least 12 months already, or the period for which it's likely to last will be 12 months or longer, or it's likely to last for the rest of your life. With regard to meningitis, there's no single piece of law which says that someone living with the effects of meningitis is disabled, as of course the effects can vary significantly from individual to individual. But applying this definition to various individual cases can help us see how, based on what we know about meningitis, a proportion of people who are diagnosed with the infection and do live with the effects, whether physical or mental, will likely be classed as disabled. Therefore, if one meets the definition of a disability and ticks all of the boxes, then yes, their employer would be under a duty to make reasonable adjustments for them in the workplace. The duty to make reasonable adjustments is one of several duties placed on employers regarding disability discrimination. Disability discrimination is a little bit different to other forms of discrimination, because other forms of discrimination exist to eliminate any difference in treatment between people, whereas disability discrimination is there to say that people with a disability actually should be treated differently, that is, more favorably than others, so as to remove any disadvantage that's naturally caused by their disability. It's about creating a level playing field so that people with a disability can enter the workforce and thrive in their careers. So when does the duty to make reasonable adjustments arise? Well, it arises where a disabled employee or job applicant is placed at a substantial disadvantage compared to those who are not disabled by any one of the following things. So a provision, criterion, or practice. So that's basically something that the employer does in the way that they operate, or a physical feature of the premises, or a failure to provide an auxiliary aid, or basically extra equipment. So if any of those things at work cause a disabled employee or job applicant to be placed at a substantial disadvantage compared to those who are not disabled, then the employer would be in breach of the duty. If in breach, the disabled person could pursue a claim against them in the employment tribunal and could be entitled to compensation and possibly a ruling by a tribunal judge that a reasonable adjustment be made. The obligation only takes effect when the employer knew or ought reasonably to have known that the individual was disabled and so would be placed at a substantial disadvantage because of their disability. Therefore, make sure to tell your employer that you are disabled so that the duty kicks in, particularly if your disability is not obvious, perhaps because it's a mental impairment. Crucially, the duty to make reasonable adjustments also applies to job applicants as well as those already in the workplace. So that's all the way through the application and selection process in applying for a job. So advertising, writing an application, interviewing, shortlisting, and selection. The extent of the obligation is only to provide what is reasonable in the circumstances. Any employment tribunal looking at a claim will take into account factors such as whether a reasonable adjustment would have ameliorated or made better the disabled person's disadvantage. So the adjustment that you're asking for has to actually relate to the disadvantage that your disability causes you and make things better for you. They will also look at the cost of the adjustment as compared with the employer's resources. So what's reasonable for Apple to be expected to do might not be reasonable for a local small business. And they'll look at the disruption of the reasonable adjustment to working practices. So broadly, what a reasonable adjustment looks like depends on the nature of the disability and the nature of the work. What is a reasonable adjustment for one disabled person may not be reasonable for another, and what is a reasonable adjustment for one employer may not be reasonable for another. But if we try and think of some common examples of reasonable adjustments that are often seen, one is a reallocation of duties. So allocating some of a disabled person's duties to another worker. For example, there's a job that involves occasionally going onto the open roof of a building, but the employer transfers this work away from an employee whose disability they know involves severe vertigo. Another one would be redeployment to another role. So transferring a disabled worker to fill another existing vacancy. An employer should always consider whether a suitable alternative post is available for an employee who becomes disabled or whose disability worsens, where no reasonable adjustment would enable the employee to continue doing their current job. So they're moved to another role that's more suitable for them. Other types would be physical changes to the workplace. So that's one of the more obvious examples. So, widening a doorway, providing a ramp, moving furniture in the office, that sort of thing. Also providing specialist equipment or information in an accessible format. So for example, if somebody's visually impaired, providing them with dictation software to enable them to type, or manuals in Braille, or a reader or interpreter who can help them with their work. These sorts of things are called aids and adaptations, and again, a common form of reasonable adjustment, especially for disabled employees with physical impairments. Flexible working can be one of the reasonable adjustments that you can request if you are disabled. Depending on the nature of the disability, one can see how altering a person's hours of work, or perhaps their place of work, could be a reasonable adjustment, particularly if it would help remove any disadvantage caused by their disability. So for example, let's imagine somebody living with the long-term effects of meningitis. They perhaps get fatigued more easily than others, or they have issues with memory or concentration. Allowing such persons to adjust their hours, or perhaps take more regular breaks, or allowing them to work part-time or work from home more often than others, are all adjustments that could well be reasonable depending on the circumstances. A disabled person could therefore make what's called a flexible working request to ask their employer to change their hours. Alternatively, of course, and the route that we would recommend is for the disabled person to simply ask their line manager directly for any adjustments that they think they need without going through the flexible working request. So requesting a reasonable adjustment. If you're thinking, well, what if I'm not legally disabled? What if for some reason I fall short of meeting that legal test that we talked about earlier? Well, the first thing to say is that there's nothing stopping you from requesting reasonable adjustments, even if you weren't legally disabled. All the employer can say is no, and that goes in theory for all the types of reasonable adjustments that we've talked about. However, in terms of flexible working, the good news is that everybody, non-disabled persons as well, have certain rights with regard to requesting flexible working. As you can imagine, this is a very live issue right now, given the pandemic and how it's changed working patterns so much. There may well be changes to the law in the next few years, but for now, the position is this. Firstly, most companies of a certain size will have a flexible working policy. So if you know your company has one, make sure you read it. If you're unsure, ask an HR colleague if you do have one. It may well be that your company's flexible working policy is more generous than the basic rights set out in law, which I'm going to talk about next. So make sure you're familiar, if so. But this is what you're entitled to by law as minimum rights. Employees who have worked for the same employer for at least 26 weeks, so that's 6 months, can make one formal request each year in writing to their employer for flexible working. This could be a request to work from home some or all of the week, to reduce your working hours, to compress your hours so that maybe doing full-time hours in fewer days, to allow flexi time, so choosing when to start and end work, or a combination of all of the above. And there are other types as well. You make such a request in writing, and your employer normally has to respond within 3 months. And they have to handle your request in a reasonable manner. That being, they must assess the advantages and the disadvantages. They must hold a meeting with you to discuss the request, and they must allow you an appeal if rejected. If a request is approved, your contract of employment should be amended to reflect the new terms and conditions. Crucially, by law, your employer can only turn down your request for one or more of 8 reasons. These reasons include basically, it will cost too much, it will impact negatively on quality or on performance or ability to meet customer demand, and so on. So all employees with at least 26 weeks continuous service with their employer have the right to make a flexible working request. And I've explained how such a request should be dealt with. However, disabled employees have the right from their first day of employment to make a request for any changes to their working arrangements, because those changes could amount to reasonable adjustments. I hope that gives you a helpful overview to the law on reasonable adjustments and flexible working. Thank you for watching.